Hey, everyone. Welcome back to the podcast. Thanks for joining in. Matt is here. He and I have a quick legal update we want to cover for some recent things that have been happening in the court systems in New York State. A lot of people would think it's bad, but I think it's actually a pretty good step. It's not what we want to have happen.
It's not everything we want, I think.
No. What we want to have happen is, well, we're not going to talk about that in this podcast, but
Let's just give them
we would like that whole CCI, what do we call it? The Concealed Carry Impairment Act or Infringement Act?
Impingement. There's a lot of words we could use.
Impingement, yeah. It's definitely not an improvement. We would like that to go away, but we're chewing at it, I think.
Pieces at a time.
I think we got a win out of this one. So I'm going to sum up what we're going to talk about here with a statement that, so it's Western District Judge Sinatra actually did this. And he's been a friend of the Second Amendment. So if you're in that area, which most of Rochester and towards the west part of the state is in, support him. If you run into him or you see him somewhere, thank him for being a friend of the Second Amendment. He's probably pretty good.
Are we crooning over this one?
Crooning?
Crooning. Sinatra.
Oh, boy. We're going to have to cut that one out. Oof. We got to work on Matt's funny bone. All right. So the statement that Judge Sinatra made in his decision was the state's criminal enactment barring carrying of arms on private property open to the public violates the Constitution. That's pretty clear.
Not much leeway there.
Okay.
Yeah.
So building into that.
So we're talking about timeline here now.
Yeah.
July 2nd of 2024, SCOTUS, that's the Supreme Court, vacated the December 2023 decision by the Second Circuit Court and sent that case, along with 7 other cases they had rolled together, back to the lower court for further consideration in light of U.S. versus Rahimi. Okay. So they basically told them, you got the ruling wrong.
Yeah.
Go back.
Yeah.
And reevaluate it, redo it.
And guys, bear in mind, it was 7 other cases in other circuits. This was not just New York.
Right.
They took all of this stuff and said, you got it wrong, you got it wrong, you got it wrong, you all got it wrong. It's like a bad Oprah show.
Right.
You're not getting anything. You're just getting slapped.
Not getting any good.
So what else happened?
So then, even though that step was logically should have deleted the Second Circuit Court's decision and then placed Judge Sotheby's November 2022 decision back in place, which it did. So then his ruling became what we were following.
Right.
The New York AG spokesperson stated that the law was still in effect pending relitigation. So that's technically correct. The law was still in effect, but there was injunctions against enforcement on much of it, right? So meaning they, along with the governor, do not believe the SCOTUS can tell them what they should be doing. But they still had to follow Sotheby's rule, his original ruling, which then went to the Second Circuit, which went to the Supreme Court, which then told Second Circuit, relook at this, basically.
Right. So
then from there, I'll let you jump in.
So basically just the recent news on this. So we gave you a little history on this.
Yep.
This sleigh ride started way back in 22. On the 10th of October, just of this year, Judge Sinatra issued a final decision. It was termed a final decision.
Right.
On the section of the CCIA that prohibited concealed carry in or on private property normally open to the public. And we were all concerned about that when the ruling came down, or actually when the law came into effect, because that pretty much boxed out all
everywhere
public property that was privately owned. Like you could probably go walk on the sidewalk and concealed carry, and that's about it. Like you couldn't even go in your car and go get gas because now you're on private property.
As soon as you went on it.
Yeah. So it really screwed a lot of stuff up, and it was kind of the idea, I think. But quoting from his decision, the Supreme Court determined that the Second Amendment is not a second-class right. It's not subject to lesser rules, and that the High Court had noted that there is no other constitutional right that an individual may exercise only after demonstrating to the government officers some special need. Right? And, I believe it. We could do a whole thing. Actually, we should probably, I know a couple guys that are pretty good constitutional scholars that have given me a lot of info.
We're going to try to get them on.
We should, because if you think about it, there are rights of the first class and rights of the rest of the rights. Right? And the rights of the first class are like the original ones.
Bill of Rights and
and the Second Amendment and the First Amendment are the key ones of this. So, but what basically what they're saying is, why do we have to prove that we need to use the Second Amendment?
Right. Well, and then, I mean, that goes in line with what the Supreme Court wrote about.
Yeah.
The First Amendment doesn't work that way.
Mm-hmm.
When it comes to unpopular speech or exercise of religion, it's not how the Sixth Amendment works when it comes to a defendant's right to confront witnesses against them. And it's not how the Second Amendment works when it comes to carry in public for self-defense.
Yeah.
So they're saying right there, it's equal with all the other rights.
Yeah. Yeah. You can't take one right and say, no, you have to have a larger burden of proof to use it.
Right.
Right.
Correct.
So in the rest of his statement, he said, much of the land in New York is held privately and much of that is open to the public. So he's admitting that, New York is a public place.
Right.
It encompasses various businesses, hotels, parking lots, and garages, grocery stores, pharmacies, medical offices, hospitals. I'm making a point here, guys. Right? You got this? Cemeteries, malls, sports and entertainment venues, and so on.
Right.
Okay. He also wrote that these places, there are people that are there exercising their rights. They frequent that every day when they move around outside their homes. Confrontation for self-defense is certainly possible in these areas. The Constitution requires that individuals be permitted to use handguns for the core lawful purpose of self-defense.
Right. So he's basically saying all these places that people normally go, generally open to the public, are places where the right of self-defense needs to be in play and existing. Right.
It's like he understands that things happen.
Right. Yeah. Exactly.
It's not like, it's a perfect utopia. No one's going to assault anybody outside or try to carjack you and steal your car.
Right. Right.
Doesn't happen. So continuing on.
He went on to say, in reality, the state has not proven that this section of law in the CCA did not follow the applicable test that requires court to assess whether modern firearms regulations are consistent with Second Amendment text and historical understanding.
Yeah.
So they didn't bring in the proper historical precedents for enacting this type of law.
They brought in some, but reading
proper was the key.
From the 1700s.
Yeah.
I don't know, we
want to get into all the details of that, but they brought in some pretty obscure laws.
Yeah. One from Maryland talking about people, you could limit somebody carrying a firearm on your plantation.
Right. Who didn't have permission to be there for hunting. Was that what that was? Yeah.
Yeah.
Yep.
What else do we have on
and the court had little difficulty concluding that it does, noting that nothing in the Second Amendment text draws a home public distinction with respect to the right to keep and bear arms.
Mm-hmm.
The Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation, and the right to bear arms refers to the right to carry for self-defense.
Yeah.
So they were making this distinction between keep and bear.
Yeah. So keep meaning own and have them available if you want, right? And then bear meaning you have them on you.
Right.
You're great.
Which would they go on to say, to prove that, the court then reasoned that the right to bear naturally encompasses public carry.
Mm-hmm.
Most gun owners, this is a quote, most gun owners do not wear a holstered pistol at their hip in their bedroom or while sitting at their dinner table. Some of us might.
They don't?
What's
wrong with
many
them?
don't. But
what is wrong with those people? I'm kidding. We don't have to do it all the time, but why wouldn't you if you felt the need to? It's your right to do so.
Although individuals often keep firearms in their home at the ready for self-defense, most do not bear them in the home beyond moments of actual confrontation. Okay. To confine the right to bear arms to the home, which is what the state would have done essentially, would nullify half of the Second Amendment operative protections.
Yeah.
So they're basically saying that bear arms is the public portion of the Second Amendment. Not those bear arms, right? So
gotta lighten the mood a little bit, guys. Come on. So in the end of this, what really happened is in Judge Sinatra's writings, he writes, it's ordered that defendants and their officers, agents, servants, employees, and all persons in concert or participation with them, that pretty much means the state government.
That's the state government or any local governments under operating
law enforcement, anybody that's
operating under state law
with enforcing law, right?
Yeah.
So basically, all persons in concert or participation with them who receive notice of this order are permanently enjoined, effective immediately, from enforcing New York Penal Law 26501 D,
Right.
with respect to private property open to the public and their regulations, policies, and practices implementing it. And it is further ordered that the remaining aspects of the parties' motions at docket 73 and docket 77, including as to the public parks restriction in New York State penal law, are held in abeyance pending further order from this court. And it is further ordered that the defendant's request for a stay pending appeal is denied. Boom!
So
guess what?
So there's a bunch of stuff in there, and there's two kind of separate things.
I know.
So he talks about the private property open to the public, and he permanently enjoins. So that is you cannot enforce this stuff.
Yeah. There's no wiggle room on this one.
But then he does this other piece with the abeyance of the public parks, which from my understanding, and comment if what do you think on this, but from my understanding, they can't enforce that, but it's not a permanent injunction. He's basically looking for more info.
Yeah.
It's kind of in limbo still.
Yeah.
Like that looks like they have to come back to that.
Well, it sounds like he's going to be issuing another order once he gets some more
That's
info
what it looks like, right? He's waiting for the info for another part of this order.
Yeah. So, gang, what this really means is this is a decision that's it's there.
Right.
It's not just, we're playing pinball now.
Right.
Now, I do know
I mean, sort of.
as of 2 days ago. Yep, 2 days ago.
That,
the state did appeal.
They put
this
motion
decision.
for appeal,
the motion for appeal. I looked at it. It's one page, and it says, we hereby appeal it.
Basically,
That's all it is. They didn't lay anything out. So I think they're just trying to cover their bases just to make it look like they're going to do it. But, if you really think about it, what has happened is Second Circuit Court got a case. They ruled. They made their decision a little while ago, and it got appealed to SCOTUS. And SCOTUS decided, no, you got it wrong. You're not following the historical analog in history and written word.
Right. So they had to review it.
Mm-hmm. And then they sent everything back, and they reviewed it. But in the meantime, this case was going on as a challenge.
So this is going kind of parallel to that.
Right.
So we got to loop back and tell them what Second Circuit just did, though.
And what happened is at about the same time, actually, it was
a couple days apart, literally,
Second Circuit dumped a ruling out that basically said, well, the private property thing, okay, we're going to let that slide. We're going to let that go.
Correct.
Right?
Yeah.
They let the church thing go officially now, even though there was a permanent injunction out. They've admitted.
So using the terms in the CSCIA, the Second Circuit said the restricted locations, which include, and they're limiting it to private property generally open to the public.
Right.
And basically, they were throwing that out. They were staying with that original ruling. But then they also said, we're going to let stand or uphold the sensitive locations.
Yep.
Yeah, this is how confusing this law is.
Except
the sensitive location, except for houses of worship.
Houses of worship,
Right. But interestingly enough, remember that paragraph from Sinatra's ruling about private property generally open to the public? He also included in that medical offices, hospitals, sports venues, and so on, which those are all actually...
Some of those are in the sensitive
locations.
Yes.
So now we have another conflict between rulings. This looks like it's probably going to keep going up the chain.
Well, I see it going back up to SCOTUS. It's going to, again, things have been kind of fast-tracked after the Bruin decision because SCOTUS is using that. And guys, one of the things that I want you to understand is sometimes things like this take a while to take root.
Yes.
They have to take hold. It's not just a blanket decision. Everybody's got to abide by it, although that would be great. But Bruin is taking root.
We're seeing that movement in a lot of the decisions.
It's getting some, it's holding.
Yep.
And a lot of states are getting bumped up against it. And this decision is being used to shut down some laws.
Yep.
So
I think the big question is, though, where does this leave the concealed carrier right now? And I'm not 100% sure, right?
Yeah.
But looking at these rulings, I mean, Sinatra, this is standing. What he ruled is the law right now. So those places he mentions, and go look up his ruling. It's a 43-page document. There's a lot to it. There's a lot of explanation in it.
Yeah.
And he talks and kind of goes through each of the state's points, especially the historical points.
It's a good read.
It says why they don't apply. It is a good read.
Yeah.
But we'll link it down below. in the comment area.
Yeah,
or in
we'll
the
give you a
description.
link right to
We'll
the
give you a
court
link.
listener document so you can see the history of
The
all
history
the
and all the
filings.
appeals and that.
And if you scroll down to the bottom,
Yep.
you'll see the newest filing, and then you'll see where you can actually download Sinatra's decision.
And unless the Second Circuit steps in with the appeal and changes this,
I don't know if they're gonna.
what he says
They might.
is what they have to follow right now. So they cannot enforce definitely the public places, open to the public.
Yeah.
Private property open to the public.
I think that's a done deal.
And according to Sinatra, that also includes this list
I know.
that we talked about.
And guys,
So
this list is right in there.
It is.
We didn't,
It's
and
no.
there's also a couple.
These are quotes.
There's a couple articles right from the Times Union out of Albany, and there's a Channel 10 article out of Albany too that has a lot of this info, and it's just about spot on. It hasn't been altered for the media sensational part.
No, it didn't have a lot of spin. Both of those articles were pretty just straightforward
Pretty
reporting.
easy.
Yep.
But guys, really what this means is, the Second Circuit is playing with a lit match, and it's almost down to the bottom right now because I don't think the Supreme Court is going to take any more of this. Back a while ago when the Supreme Court ruled on the Bruin thing before the whole CCIA came to bear, our governor made a statement of how dare the Supreme Court tell me what to do in my state. Well, unfortunately, in this case, they can. And I think the Supreme Court is kind of like, how dare she think she can get away with this?
Yeah. So
But that's not a discussion on this. We all know that, we're in a not very gun-friendly state in New York, but we're fighting. And that's the key. One of the things I want to put out there, everybody, is do the research, learn about all this stuff. Just don't take our word for it. Don't take, some other guy's word for it, some of the YouTubers out there, but do the research and see what the general consensus agreements are, and then read it for yourself.
Yeah.
Get a hold of an attorney who is familiar with this stuff. Read it for yourself. Get their interpretations on things, because that's where we get our info from.
Right.
Okay? We're not legal experts. That's a disclaimer we'll probably throw up right in the beginning. But based on what we know from prior cases that we've had to research, and the talking to the attorneys that we know, they've pretty much all said, yeah, you're right, but think about this part and do this, and then that's how we learn. But this, all of the things we just talked about right now, this is right out of Sinatra's decision. It's right out of the stories that jive with what Sinatra is, or Judge Sinatra has put out there.
Yeah. One of our attorneys actually reached out to us as soon as this came out and said, hey, have you seen this?
Yeah.
So,
But what I would say is, guys, this means really that you're able to concealed carry in public places, normally open to the public, in a lot of those places. But that still bears that you need to be discreet. You can't go running around flaunting this thing. Concealed carry means concealed carry.
That's right.
Okay. So read the court listener link that we'll have down below. Check that out. Another thing you're going to want to do is, guys, you got to support these organizations. These cases don't get won on the good graces of the judge or somebody that gets involved. They get pushed through by places like Gun Owners of America, Firearms Policy Coalition. I love their Twitter feeds. X feeds. Elon now hates us. Second Amendment Foundation, the NRA Institute for Legislative Action, and the New York State Rifle Pistol Association.
they need our support to
Let's see, who did I
make these
miss?
cases
Gun Owners
go
of America, FPC, Second Amendment
you got them, all the
Foundation.
big
They're
ones.
kind of the big ones.
You got
right?
the big ones, yep.
The other thing you need to do is you need to talk to your elected representatives. I know everybody, the first question they get, well, mine's Democrat. They're not going to listen to me. No, they have to listen to you. Whether they'll hear you is another thing, but they have to listen to you. You have to make your voice known. Everyone, think about this. These are your fundamental rights. They're worth fighting for. Okay? So let's get fighting. Let's stand up for our rights, and let's make our voices heard. Okay? If we get any more info, we will update you as we can. I know it took a while for us to get this, but we wanted to decipher this and get with our lawyers to tell us, okay, this is really what it means before we ran out there and tried to be the first out there with info.
Yep.
Okay? But if you have questions, you have some comments that are constructive, please post down below and share this video. Don't forget to like us, subscribe to the channel.
Please subscribe.
Yeah. And get some notifications too. Hit that little bell. I keep every video
ding,
I go,
ding.
they're like, they get the little bell that dings on the bottom. But guys, support us and support us on Patreon. Okay, we're going to try to do a lot more stuff, but with your support and your input, we can do a lot more. Okay, thanks for checking in, guys.